Good afternoon, everyone. Thanks for your time. We might give another minute or so for people to stream in. They're currently coming in, so we will start the webinar shortly. Okay, well, welcome everyone. This session is being recorded, so we might kick off now. I'd like to welcome everyone. This is our Think Big series that we do. We release 3 or 4 depending on the year of the Think Big document. It's been a popular series so far, and hopefully this one will be no different. It has been released, so if you've been lucky enough to download it and had a read of it, that's great. We're going to cover a few topics today. If you haven't, please go and try and find it, locate it, Google it, go onto our website and you'll be able to find our Think Big series. So today we're going to be covering some topics, and it's about building strong foundations in family business. And we are lucky enough to have a few panelists today with us. I'm going to introduce them. First, we've got Peter Revelis, who's a partner in Sydney in the business advisory team. We've got Nadine Mark, who is a corporate finance partner and head of the corporate finance division nationally, based out of Perth. We've got Katie Timms, who has been busy recently, as you would imagine, being the head of superannuation nationally. And then we're lucky enough to have a couple of lawyers with us today with a firm that we work with in Sydney with Hitch Advisory, and that being Paul Henry, who's a commercial lawyer and litigation. And then we've got Marianne Polifrone, who is basically wills and estate lawyer, and I've personally worked with both of them. So today we're talking about the importance of structures in business. And as you would be aware, things change very quickly. Whether you're growing, whether you're buying, whether you're selling a business, there's external risks to think about and so forth. But we wanted to run through a few things that were covered in the Think Big document about the importance of structuring and protecting business, the business value, and obviously getting some benefits in terms of tax and so forth. So we're going to go straight into it, deep dive into it. As I said, welcome everyone. Our first question that I'm going to ask the panelists, be it Peter and Paul, is choosing the right structure when you start a business or you purchase a business, acquire a business, is pretty important. There's some traps, tips, and so forth. So what I'm going to ask Peter firstly, Peter, in your experience, exposure, understanding, what are the main factors a family should consider when choosing a structure for their business?
Thanks, Dace. Look, I think invariably, one of the big things you've got to look at is flexibility in benefit and control. This sort of allows an easy transition of the business should the circumstances require it. So whether there is a need to shift control or adding or removing family members without incurring, or at least minimally incurring, any tax consequences as a result. So that's the first one. It also ensures that benefits can flow in the most tax effective manner and efficient manner as well. The other thing is bearing in mind that then each entity, or at least in your structuring, needs to have clarity of function. Within the group, each entity should have a given purpose, whether that is to quarantine risk or just protect assets. And finally, I would say cost of compliance, because assessing the most appropriate structure can sometimes come with significant costs if it's over-engineered. And so just being mindful of the fact that while it might be optimal for everybody in any circumstance, it might not be economically viable for every business.
So Peter, just on that, it is possible to change a structure if need be, depending on what your risks and appetite to change is?
Yeah, look, I think invariably shifting and changing, remaining flexible will allow you that, but I think to some degree it's not always without tax consequence. So if that is the case and there is an identification of something that needs changing, the idea is to start earlier rather than later to shift it to what is more appropriate.
Absolutely. Now, there is cost involved, as Peter said, but ultimately if you get the structure right and believe in your business, spending the money up front is better than spending it down the track, because it's a lot cheaper to get it right from the start. So Paul, bearing that in mind, can you walk us through a situation where perhaps the initial structure created some issues down the track, and how can they be avoided?
Thank you, Dace. Look, I'll give a couple of examples here. So primarily I'm a transactional lawyer, so I deal a lot with what happens towards the end of the life cycle of a business. which is the happy point, normally an exit. I'll give you one example. So I'm sure based on some tax advice, we had a client that set up an operating discretionary trust. Now, when it came to sale time, an operating discretionary trust is a very difficult beast to sell. Buyers will never normally want to buy a discretionary trust. The difficulties around maintaining control and also the peculiarities around the tax structure makes it a very, very difficult entity to sell. Now, that might have worked for streaming benefits whilst it was being operated, but it didn't make sense for a long-term hold and probably should have been restructured at some point before we came to a sale process. That resulted in ultimately a successful outcome for the client, but there was a lot of pain and difficulty regarding structuring of that transaction that could have been avoided if it had been dealt with early. So I guess from my takeaway there is, don't just think about what will get me the ideal tax outcome for streaming dividends from day one or profits from day one. Think also a bit future proofing and think, can this structure grow with me and ultimately be an effective structure for an exit? Second example I'll give is one that's a little bit older in time. So we had a clients that had a business set up back in 1969. They had two companies set up. They held property, developed the property, and ultimately leased out that property very successfully. As you can imagine, the eastern suburbs property market since 1969 has only gone in one direction. Those two business partners have long since deceased, and the shares in those companies passed along their wills. Fast forward to 2024, and we were stuck with a situation where we had ancient memorandum and articles of association that were no longer fit for purpose, long had ceased being fit for purpose, in fact. The law had long since moved on. And we have second generation now families who had no longer gotten along well together, and they had very different investment and holding objectives. The way that was resolved, unfortunately, was via litigation. So one of the families had to bring a Supreme Court claim for oppressive conduct to try and engineer an outcome. And there was very real possibility that could have ended up in either a liquidation of both of those companies, which would have been value destroying ultimately for everyone involved, or could have ended up in some sort of forced buyout, which would have put, would have really changed the economic makeup of those businesses. Thankfully, they, just prior to going to court, they managed to settle and work out an alternative arrangement. But that was a real world example where succession planning was never given the sort of forethought that it needed. And ultimately trying to unscramble that egg is far harder than taking the time and effort to try and build a robust and effective governance arrangement.
You know, absolutely. Planning for the exit is probably an important part. You may not get it entirely right at the start, but if you are considering starting a business or in a current business and you haven't given that any thought, I think it's an important factor to take. So just moving on with that, and as we know, whether it be blood relationship or spousal relationship or de facto, it happens, it occurs, and it happens more often than not. So how do we structure our structures at the moment in terms of either post, pre, in terms of getting separation, clarity, and control?
Well, look, my obvious answer is to have, and you know, this is the lawyer in me, but having good documentation in place. Now, I'll often say to clients, if you have a good shareholders agreement or other sort of governance document in place, it will sit in a drawer and you won't need to look at it because you've gone through the process of aligning expectations around control and exit amongst the parties up front in the process of drafting that document. So ideally, it does literally sit in that drawer, but going through that process is half the battle. Finding out and airing those sorts of disconnects in long-term expectations regarding the business and perhaps family, tensions and dynamics will be invaluable in the long run.
No, absolutely. Documentation is important. And, you know, in the context of family, certainly we think everything's going to be roses, but unfortunately it breaks down pretty easily these days, whether it be problematic or not. But, you know, having good governance, good documentation and so forth is important. So that's a pretty good segue into our next topic. So thank you to Paul and Peter for that one. Is about governance and documentation. We're going to have Marianne and Katie cover these documents in terms of wills, estates, and then governance generally. we're going to be talking about the role of documentation in reducing the risk, the will succession, and then keeping the documentation up to date as we change. So, Marion and Katie, how often, in both your opinions, should family business owners revisit their wills and governance documents? And we'll cover wills first, Marianne.
Yeah, I think, thanks, Stace. The important point here is that wills, estate planning, succession planning documents are not set and forget documents. They're documents that should be periodically reviewed if there's a change in the circumstances of the will maker or any of the intended beneficiaries. So that often coincides with major life events, really. So birth, death, marriage, divorce, separation, children reaching adulthood, and potential creditor issues with any beneficiaries. But in the absence of a significant major event, I would say generally every 3 to 5 years, will makers should cast their eyes over their documents to make sure that they align with their wishes and current circumstances, and also to take into account any changes in succession or tax laws that may have occurred that would warrant, updating the documents so that they're in line with best practice.
No, thank you. And Katie, in your understanding and experience?
Yeah, I think the risk of loss of capacity is becoming a really big problem, particularly for business owners. So people are staying in business for a lot longer, and we're sometimes leaving some of these big decisions until capacity starts to become a real question and a real problem, and that can throw everything up in the air. So I think Marianne's absolutely right. Like every 3 to 5 years, I say to clients all the time, take them out, look at them, work through them. Nothing may have changed, but at least it's fresh, at least it's there. And at least, it is, if something has happened, it might be small, but if changes can be made before there's a risk of that loss of capacity, because once we're at that point, that's it, there's nothing that can be done. So absolutely agree, at least 3 to 5 years.
That's a really good point, Katie. I mean, I'm increasingly having clients approach me because family members have left it too late. They haven't got an enduring power of attorney document in place, a really straightforward document once it's prepared. But in the absence of that document, worst case scenario, and I had this occur a couple of weeks ago, two siblings were fighting over who should be decision maker for mum. And because it went before the public New South Wales trustee and guardian, and the panel couldn't decide who the most appropriate person should be, the public trustee was appointed. And that's absolutely, a horrific outcome for this woman, who I'm sure would have preferred for family to be in that decision-making role for her.
Yeah, no doubt.
And that's that. Sorry, Dace, Marianne, I just can have our own conversation now. But that EPA thing is also so valuable, because quite often people, when they do them, they appoint their spouse because they say, well, that's who it should be. And there reaches a point when that's not appropriate anymore, particularly where you've got, business succession and things that are happening. And if mum and dad are aging at the same point, maybe that's actually not your best option, because that power of attorney may also lose capacity. So I think that's a really big conversation that is maybe neglected sometimes while we look at so much at wills and EPAs, but I think loss of capacity is much more of a problem.
Yeah, no doubt. And obviously just having the open channels of communication is important. So that moves to our next question in terms of advice to business owners that aren't willing to share their succession plans with their children.
Yeah, I guess my advice here would really depend on the circumstances of the family. And that's because I think transparency is important. It's often really helpful to make sure that everyone's involved and on the same page, and there are no shocks when the matriarch or patriarch passes away. It's all well and good. However, my caveat to that would be, if there is a situation where a matriarch, patriarch, will maker thinks that their wishes or intentions may change in the future, it's often better not to share plans, because you might be setting yourself up in a situation where people then have an expectation to receive something, and once they don't receive what they're expecting to, it can result in potentially claims against an estate. So yeah, case by case, but if the family circumstance permits it, yeah, getting next gen on board is great, but otherwise sort of be mindful of sharing what's necessary, but not sort of oversharing.
You know, and on the spot question, then does that change as well depending on, you know, if some children are in the business and some children aren't?
Definitely. And I think we're seeing more of this. It's sort of a tricky point where someone, a child is in the business, very much involved in building the big business up. And I'm sure Paul can talk to this too, where there's sort of an expectation or a promise made that they're to receive a share in the business. And they're very much involved in the business discussions. But then when it turns into the estate side of things, siblings sort of see, well, yeah, brother was involved, but that asset is worth way more than the estate. You know, we should have been involved in this discussion too. And it's, you know, often after the fact there that, you know, it comes to light what businesses may be worth, or what son or daughter who's involved in the business, what their contribution actually led to. So I guess, yeah, in those scenarios where you've got, you know, a child in the business and others not, it might be worth laying the groundwork with other siblings to say, yes, brother, sister has been involved in the business. Their contribution has led to the business becoming really successful. And yes, it may not look even on the other side of things, but this increase in value that they've generated is to go to them because they've put their blood, sweat, and tears into building this.
Mm. And Katie, an off-the-cuff question to you: do BDBNs play a part in that, in stopping ambiguity, I guess, in some of the succession issues or wealth issues?
Yeah, no, they absolutely can be. I mean, they're a fairly powerful tool, particularly if we're looking at uneven splits or if we're looking at potential family dispute and things like that. So provide, you know, they can provide, I guess, control and certainty in two ways. One, it just takes away any ambiguity. So again, it takes away any risk of conflict. We know exactly where benefits are going to go, but it also maybe is a tool to pay things outside of an estate, you know, keep things out of a wealth pool if we do want to try and play with you know, percentages where beneficiaries maybe aren't going to get things equal, or you just don't want to have if you know there is a problem looming, I don't want everything at risk. Paying something direct from a super fund via a BDBN actually can protect that asset pool a little bit. So such an important document, really often overlooked. And superannuation as an estate vehicle is sometimes overlooked from that perspective as well. We spend a lot of time trying to save tax and get assets out of super before we die. Sometimes that paying the tax is worth it to be able to protect part of the estate from the risk of challenge.
I totally agree there, Katie. That's often a one-page document that needs to be signed in a certain way, and people sort of maybe it's not front of mind, or you know, they just don't know that this is something that needs to be done. And super comprises a huge portion of the average Australian's wealth, so it's really important that document isn't overlooked. And as you said, it can be really helpful in balancing and equalizing estates.
So there was a question.
I found it really interesting. Sorry, Dace, I'm
I just wanted to
Marianne and I again.
No, that's okay. There was a question that
Sorry,
I actually should have said it. There's an acronym BDBN. It stands for Binding Death Benefit Nomination. So it forms part of a document within super that allows you to direct your super benefits to someone directly rather than going through the estate.
And I guess to that point, you know, there is sometimes room for non-binding nominations where you have, you know, minor children, or you want to create a balancing act and you're not sure what that may look like in the future.
Absolutely. So we've talked about a few of the concerns, risks, and so forth. But is there anything else you'd want to cover in terms of, I guess, some of the issues if you didn't have a will in place?
I think, yeah, my view here is, if you don't have documents in place, or you have ambiguous documents in place, it creates huge complications down the track. And you know, you mentioned a will. Sort of I focus on estate planning. A will in isolation is important, but it's one part of a much bigger picture. So it's making sure that all documents, whether it be dealing with trust deeds, or I should just say all documents that deal with assets an individual owns and control, need to be implemented so that there's a plan in place so that an estate will be distributed in accordance with the wishes of the will maker. And I mean, not having documents in place, there's so many risks involved with that. Disharmony with family relationships when children are left to navigate how assets are to be divvied up. The situation in the absence of a will, having the law prescribe how an estate will be distributed, which is often not adequate within circumstances. I mean, practically speaking, it's an administrative mess if documents aren't in place, and family members have to focus on unraveling that rather than grieving the loss of a loved one. I could go on, delay. And I guess when you don't have documents involved, having to get more prepared, having to get more involvement from the professionals, which means, delay in process in dealing with the distribution of assets and much greater costs to an estate. So there's just so much there. And my view is just having documents allows you the opportunity to choose how your estate will be distributed and to alleviate stress from loved ones when that happens, so that there is a smooth transition of wealth.
No, definitely. And a question that's come through, Katie, about BDBNs. I'll say it a bit slower, but do you sit down with yourself or a lawyer, or how does a BDN operate?
BDBNs should always be done with the rest of the estate planning documents. Too often they are done just as an ad hoc thing, or people, will do their wills and then they'll come back to their BDBNs at another point, and then the documents don't actually talk to each other. A lawyer can draft it, a super fund can prepare the documents. They're not complicated, but they need to be part of a bigger conversation to make sure that everything is aligned in terms of where things are going to end up. Because we've seen them where, as a super fund person, we get a copy of a will and say, great, that's not at all what you guys have put in place for the SMSF. We need, one of these things needs to change. So definitely making sure it's done as part of a holistic overview.
And Katie, as you would know, there's actually quite a sort of restrictive list on who can be a beneficiary of super. So you often see clients who haven't been advised and they have a nomination to someone who's not even an eligible beneficiary. So obviously that creates complications as well.
Absolutely.
Yeah, absolutely. If you don't do it right, there are complications. So you've got to get the right advice right from the start. Now, we've got a few poll questions of the two topics that we've covered so far. So, pardon me, do you want to bring those up for me, please? So the first question is, how confident are you that your current family business structure, if you're in business, supports your long-term growth and succession? If you answer that one, we can go through some of the results quickly. And in the meantime, while people are answering it, the question that came from Tonya was, can you have a BDBN in a self-managed super fund?
Katie, would you like to?
Sorry. Yes, absolutely. You can do, and it's probably the place where it's almost more important, because if you don't have a BDBN, you're essentially leaving that decision up to whoever is in control of the super fund. And depending on how your super fund has been structured, you might have kids in there that you don't want in there. There's a whole range of complications. So can you have one? Yes, you can. More importantly, should you have one? Yes, you should.
Hopefully that covers the answer. So the results, pardon me, somewhat confident, which is good. Hopefully you're getting the advice that you need to in terms of how your structure operates, first of all. There's some very confidence in it, they're not sures. I think it's important just to ask the questions, educate yourself, and we can help educate you in terms of what structure that would be that best suits you. As we've said before, it's not a one size fits all. You could have different strategies, you can have different outcomes. So basically, you've got to get that advice at the start to make sure that is there. So if you need to reach out, please do so. There is a second question. So in terms of your structure, the biggest concern for your family business right now is it tax effectiveness, succession planning, governance and decision making, managing family conflict, and protecting wealth for future generations. I think all of these are very important. And if you pick one, we'll go through them. But effectively, you've got to have a plan in place. But if you can answer those, we can quickly cover those as well, please. And Katie, we've got another question about BDBN, a popular topic. How do you nominate a BDBN if you have no dependents? Can you nominate your estate as the beneficiary?
Yeah, so if you don't have any dependents, then you don't really have a choice but to nominate your executor or your estate. So your super can generally be paid to a spouse, a child, a financial dependent, interdependent, or your estate. And that's it. So if you want your super to be paid to parents, to cousins, to nieces, nephews, it can only be paid to them via the will. So in that instance, then you would do a binding death nomination, but to nominate that the benefits are going to be paid to your will. Again, just takes away any ambiguity. Make sure it's going to go to where you want it to go to, and usually quicker.
Yeah, absolutely. So just in this poll number 2, there's a bit of a split there. Obviously, they're all important pieces, and each one has a different aspect to it. Gaining tax efficiency is important. Succession planning, absolutely. If you choose the wrong structure, you may not be able to get the desired outcome that you want to achieve. Paul covered that in terms of setting up, possible sale and so forth, depending on the structure that you're in. Governance and decision making, managing family conflict, important these days. It happens all too often. We've seen it happen too often, unfortunately. The whole protection of wealth and asset protection is important. You work hard to build your wealth, and you want to be able to protect it to future generations, be it from either creditors or marriage breakdowns or something. It's not always possible, but certainly us at RSM, with the help of lawyers and so forth, make sure that we put you in the right structure to minimize your risk and manage that risk as appropriate as you can. So thank you very much for those questions. All right, we will get you to Nadine, but we're going to go back to Peter and Paul at this stage in terms of structuring for tax and wealth preservation. So in terms of that, we'll be covering distribution planning, asset protection, and minimising the tax risk, which that poll question just covered. But gentlemen, how do the tax considerations change or shift when a business moves from first to second generation?
Paul, would you like me to?
Yeah, this might be a bit more your domain, Peter.
All right. Look, I think first and foremost, I think as generations pass, obviously, you would expect that the beneficiary pool gets a little bit larger. It starts to expand a bit. And so you need to effectively be able to spread benefits further without losing tax efficiency. So with that, however, comes added risks with the asset pool. Your asset protection, it gets put under a little bit of pressure when you've got potential relationship breakdowns as well. So there are more people in there, so there's potential for greater problems. Secondly, if the structure is still fit for purpose, based on what the second generation want, is it still fit for purpose based on what the second generation want? I mean, the second generation may step into the shoes of mum and dad and go, status quo, this has provided for us more than appropriately over the last however many years. Let's just continue with that in mind, and basically we don't need much more than this. If that's the case, then so be it. But sometimes people walk in and they go, well, I can see how this can progress. How can this actually get? How can we go take another step here? So should we look at IPO or a trade sale or something like that? So values and goals change as well with the generations. And I think that when that does happen, you may need to start looking at tax restructures and things like that. And that can be costly, but it is something to consider, and it is something to have across the table from well before, so that you're not caught in a trap where it's done a little bit too quickly than it should be done.
Yeah, and to reiterate that example I provided earlier was exactly that. We're a second generation, half wanted to sell, half wanted to hold. How do you resolve that? And that was the big challenge that was being faced. Obviously, the first generation were happy to build and grow that business, second generation, slightly different objectives.
Absolutely. And they're all important things to consider when you're going through those lifestyles, excuse me. So Peter, just following on, what are some of the smart tax strategies then that family businesses are often overlook?
To be honest, Ace, I don't think too much is generally overlooked. I think tax advisors are pretty much across a lot of the common strategies. I think the problem that most tax advisors face, and then as a consequence, clients feel that they've forgone the opportunity, is that people start the process too late. And it might be too late when, it limits or eliminates options for people to actually go through a restructure that is tax efficient as well, or tax effective. So I think from my perspective, I think it's probably best to continue to have good conversations with advisors, ensure that the structures are still fit for purpose, that it's still there, it's still going to help them achieve their goals. Avoid being caught in the trap, as I mentioned earlier, but maintain, and I always maintain, that family members need to build these good relationships with their advisors through the generations too. And periodically have discussions about the long term. I mean, I think ultimately everybody tends to focus on the short term, which is important, because if your business is not profitable and it's not performing in the now, there's no guarantee it's going to be there in the future. But I think every so often, I think a challenge needs to be laid in front of the family to go, well, assuming things continue to go the way they are, if our goal is to reach X, then what does that look like? And then stress test it. I mean, have your advisors stress test what it could look like in various circumstances and situations. And how are you going to get there? What's it going to look like in 5 to 10 years' time? And if something needs to change, address it. So this is as important in succession as it is in your own retirement. So, if that's going to be the case and this business needs to provide for you, that's absolutely the one thing you have to do, is start early.
No doubt.
Yeah, and I'll build on that too. And we mentioned earlier about structuring and how sometimes businesses can be over-structured early on. But there might come a time in your maturity life cycle where you need to revisit that structure again, and there may be efficiencies that can be had or advantages had from restructuring. And so the business that you set up on day one probably isn't going to be the same structure that's going to be optimal through the entire life cycle. There will be evolutions over time. And so periodically revising that and having a look at whether there's advantages to be had or perhaps streamlining is really valuable.
Look, no doubt. The last question that we've got on this topic, and I've seen it all too often, is that some people just go into certain structures and so forth to minimize tax or just to save some tax, to do different things. But what are some of the risks that we see, or that are outcome, if someone's gone in just for a tax saving, tax benefit and so forth, and haven't considered commerciality?
Well, I know, having worked with Peter, that we've had mutual clients that have had unnecessarily complex structures, and I'm sure it was done with the best intentions moving forward, but the benefits were far outweighed by the detriments of trying to manage that structure moving forward. So what I would say is that there are a few, within reason, there are a few kind of classic structures that are often used time and time again, and they're often used for a reason. Now, is that maximizing every cent in the dollar to its perfect, outcome? Maybe not 100% of the time, but it will get you there most of the time. And the benefits are that it is a reliable structure that can be used moving forward and adjusted from time to time without too much difficulty. So what I would say is that if you're doing something too clever and a bit funky and unusual, there's probably a reason it's a bit funky and unusual, because ultimately it can break when put under stress.
I might just add to that, Paul, and just say, invariably when a lot of clients go into those overly complex structures as well, it becomes obviously far less malleable. So should something need to change, the risk of the unintended consequence of changing becomes a significant cost, or there's a commercial risk to it, or there's something else that's sort of sitting in the background that just makes it impossible to do without actually taking a hit somewhere or another. So, overly engineered structures, that can be expensive to run, as I mentioned earlier, but not necessarily expensive from the point of view of day-to-day running. Overly expensive in terms of rectifying it should it not be fit for purpose at the time. So just having that clarity, again, just as I mentioned earlier, that clarity and purpose of each entity within your group as to why it's there, and also just that, keep an eye on what it would look like in the future should you need to cut it loose or restructure it, repurpose it.
Spot on.
Perfect. Well, thank you, Peter. Thank you, Paul. All right, we'll move on to the next topic and get Nadine involved. Obviously, we've created the structure, we've built the business and so forth. The important part of it is what we do with it, whether we sell it, whether we transition through the family, succession and so forth. We're going to be talking about fair valuations and the transfer of control. We know there's a lot of baby boomers getting out and trying to get their wealth out and possibly pass it through families, but that can also cause disharmony between families. So we want to keep that harmony, and also some legal considerations and things like buy-sell agreements. So, Nadine, welcome. In terms of valuations, because it is an important part of a business, because you are trying to create as much wealth as we can. How should families, when they're running a family business, approach valuing different contributions of different members within that family, who either work, as we said before, in the business, or those who don't?
Yeah, thanks, Dace. And I guess, from a valuation perspective, so I'm a valuation specialist. That's what I do day to day, but I also do a lot of litigation work. And so I guess when I'm speaking, I'm talking from seeing both where it goes wrong, but also what we can do to plan and put families in the best position to start with. So I guess in terms of valuing contributions of members, and Marianne touched on it earlier, if you've got one of the siblings or one of the children who's been working in the business, maybe not being paid a market salary, putting in a lot of time and effort to grow that business, then actually when you come to succession, or when it comes to some form of dividing of the estate, being fair doesn't always mean being equal, because actually the contributions haven't been equal either. So that's something that I think needs to be remembered, and also have those conversations, those very transparent conversations with all of the children, all of the family members, to make sure that they understand that, fairness could be actually an unequal arrangement, but actually that's a fair representation of what's been put into the business. And the way I sort of look at it is, if one of the children is running the business and putting all their time and effort into that, they don't have the opportunity to build their own wealth independently, to have their own career and have their own, build their own assets. So, there's that division between, I guess, the concepts of ownership and compensation as well. So you need to be very clear within your family business who is being compensated for the work they do, how does the ownership structure flow out, and then what does that mean for your specific family and your business. So it's got to be tailored individually to you.
So, Nadine, it'd be a lot easier to do a sell to a non-related party than it is to a related party in most cases?
Yes and no. I mean, I'm sure Paul can jump in as well, because obviously he works in the space as well. I guess when you're selling to an external party, there's less emotion involved, as you are with families. So, I think one thing from a valuation perspective, being very clear on how a business should be valued, that can be something that can be built into some of your documentation, whether that's your shareholder agreement. And you might have a different approach if you're selling to a family member versus selling externally. So these are all things to think about when you're doing your documentation. I don't know, Paul, if you want to add anything from a legal perspective there.
Yeah, certainly. So you're right. Valuation mechanics in documentation like shareholders agreements can be super helpful. If anything, it sets an alignment on expectation and gives you a regime to start with. Otherwise, you're working with a blank sheet of paper. And Nadine, I'm sure you'll back this up when you say that valuation's a little bit art and a little bit science. It's not that you can just pluck a number out and say that is definitively the value of a business. So it can really help setting some parameters around that. And also on your point about whether selling to a third party or a family member or someone that knows the business, obviously there are efficiencies and eases in selling to someone that knows the business already versus a third party. So there's benefits there. And they may be able to more readily understand the true value of that business. But at the same time, it's harder to negotiate with family or when family is involved than it is with a third party that's much more dispassionate. You can get your advisors involved more robustly.
So just pushing on with that topic, are there any tools or structures that help ensure a fair succession process?
Yeah, well, I think the main one that we see is, a well thought out and a tailored shareholders agreement. So actually, don't just take a blank, a pro forma one and roll that out. Actually think about your family and your situation, and think about what, to Paul's point earlier, are there potential exit plans that you want to think about? How would that look? Do you want to give the other siblings the opportunity to sell to the controlling or the child who's working in the business? Do you want to give them the option to exit at any point? And if so, how would that clause work? So yeah, there's lots of factors, I think, in a shareholders agreement. The other one that we see sometimes is outside of that legal world, is more from a sort of a family constitution, kind of guiding principles for the family. So it's not a legal document, but it's saying, and to my point earlier around how the siblings get paid from a family business, there may be some principles around, well, all members who work in the business will get paid market rates. And then you sort of take away that element of sweat equity and how do you get rewarded for it. So they may want to think about, how do we actually operate as a family outside of purely the business and the legal structure of that shareholder agreement?
Yeah, all very valid points. So we've seen, Nadine, some hot topics at the moment with family breakdowns and so forth, such as Murdoch, such as Reinhardt. But when you're planning your business, what are some of the evaluation principles that can help dissolve those disputes or avoid those disputes? We've covered a few of those, but are there any more?
I think, and I guess it's common to what everyone's been saying, is you need to have the conversation as a family. You need to be transparent and make sure that what is documented, everyone understands what's been documented and understands the reasoning. And that may, you may want an independent party to take them through that. You may want people to have their own advisors to help them understand. So I think definitely being transparent. If you can sort of agree on broad valuation principles of how any exit or transfer between the parties would occur. I think I'm not advocating for saying, oh, it's 3 times earnings. Don't do that, because that is not a helpful outcome, because obviously the value of a business changes through time depending on what's happening in the broader economy, but also what's happening in the business. So please don't put in a number and say it's 3 times, but just broad principles around. So for example, if someone has a 20% interest and the other party has 80%, are you going to say that because they have control, the 20% is worth less and therefore should be discounted? Or are you just going to treat everyone equal and say a 20% interest is a pro rata 20% of the value? Things like that can actually be quite a big argument in valuation, because from a commercial perspective, control equals value in many aspects. And that is what came out at that Murdoch one. It wasn't so much the money or the value, it was actually the fact that he was trying to change control of that trust and the business as a result, or the empire. He was trying to change the control to a single heir. And so when you have control, obviously you can dictate where the money goes, you can dictate what you invest in. And so typically we would say that's more valuable than having a minority shareholding. So simple things like that to think about. Those are those sort of valuation principles. I think, and preparing for liquidity events as well. So thinking that through in your documentation as well.
Thanks, Nadine. Very sage advice. There has been one question come through the Q&A, and it probably goes back to structuring. So, Pete, I might get you to answer this one. And I'm assuming you're going to give a good legal answer, say it depends. But what's the best structure for a family with an investment portfolio, possibly shares, created to pass on the dependents when they come of age?
Yeah, I think Dace, you and I have had this conversation recently where, you know, every good tax question really it's very much is dependent on the circumstances, I guess, and also the expectations. I think, look, there are many structures it could fall into, to be fair. I think, you know, it really comes down to, well, what's most efficient now, because until such time that they do pass on to dependents, there are tax consequences at that point as well. Now, it may be that you know, holding those shares in personal capacities is fine, but then it comes down to the individual's personal risk profile. It may be that a family trust is appropriate, in which case then the only thing you really need to hand over is control of trustee. But at the same time, depending on what would suit the dependent at the time they actually come of age, that is also then a consideration at that point in time as to where it best sits. So unfortunately, there's no one answer to that. But suffice to say that it could sit in pretty much any structure. It really comes down to what the circumstances are. So unfortunately, it's a little bit of an open-ended one.
Yeah, I totally agree. And we'd have to assess the situation before we'd be able to give the best structure going forward for that one. Thank you. Now, so we've gone through doing it right, getting it right at the start, making sure you've got certain principles in place, documentation in place, governance, etc. But we have seen it go wrong. So what happens when it does go wrong? So Paul, you're in the litigation space as well. Can you give us an example where poor structuring's led to a legal dispute, and on that, if it could have been prevented?
Yeah. So again, I'll go back to this other one, this one that I've mentioned a couple of times. So it's got so many of the hallmarks of what we're talking about today. So that was a 50-50 arrangement, ripe for dispute. How do you break a deadlock at 50-50? All they had in place documentation wise was a memorandum and articles of association drafted back in the 60s or 70s. It was very basic. It didn't have any deadlock breaking mechanisms. It didn't have any provisions dealing with an exit. It didn't have any provisions dealing with transfer other than vanilla that you can transfer. Of course, finding a buyer for quirky share classes that's only 50% and walking into a deadlock scenario is almost impossible. What third party wants to step into that? So these parties, they ended up going to the Supreme Court and seeking orders for either a wind-up on just and equitable grounds or a forced buyout at the order of the court. Now, obviously, that's essentially putting a gun to the heads of the family members and saying there are very serious consequences that are going to happen because of this deadlock. That could have been avoided or at least mitigated against if documentation was in place that dealt with these scenarios in advance. But the time to do it is not when you've had a falling out. The time to do it is when you're getting along. And you might need to evolve it over time, as mentioned by many people here so far, but at least have that groundwork done, at least have that discussion, at least have that framework for how we might reach a resolution. Otherwise, you're at the mercy of the courts. And as a lawyer, I'll say this: if you can stay out of the courts, do it however possible. It is the absolute last resort for a good outcome that maintains value of a business.
Yeah, look, I've always said this, and I still live by it. The only winners out of family breakdowns or family law matters are accountants and lawyers, and you don't want to give your money away to us. And especially going to Supreme Court, the barristers and so forth are very expensive. So that's right. So going on that, if we want to avoid that expensive litigation, what do we need to do for families as the business grows or leadership transitions? I think we've talked about it, having conversations, et cetera. But is there anything else you wanted to cover there, Paul?
Look, there's not too much I want to add on that other than, and probably to reiterate a few things, is that this documentation, if done well, I mean it honestly, should sit in a drawer because people are aligned on expectations and how to move forward. But they need to be there in the worst case scenario. So really, you're pulling that out when there is a falling out, and trust me, you'll be glad you have that document sitting there. And if you don't, so there's not too much I want to add to build on what everyone else has already said, other than open discussions, resolving issues early, and ideally having a documented framework for how to resolve it if you can't.
Yep, and it's good governance and obviously formal. But obviously, some of these things that are put in place at the start can break down trust and family dynamics. So how do you balance that with conversation, etc., with the clients? And Peter and Paul, happy for you to jump in.
Look, Dace, I might just kick off and then give Paul a little break. But I think good governance is always a good thing. It's never a bad thing. I think when it comes to families, though, I think it's really important to understand, though, that that formality should not be a formality in terms of control. It should never be exerted as a means of control for the family. I think it's more a question of just make sure that there is clarity why things are being done, and the importance of why those things are being done, but also why they are being documented. I think, just to Paul's earlier point, if this is being done while everyone's getting along, then there's really no question as to the motives or the reason for why these things are being documented. So it's always a good thing to have that. And just generally, agreements like shareholder agreements, trust deeds, family constitutions, even depending on how developed you get as a family business, they clearly define the expectations of the family. They define roles, decision-making processes, and even expectations. So I think that just ensures the transparency is there and it promotes family harmony. And I think rather than leaving it to chance, promote harmony rather than let it just happen by chance, I guess. So that would be my suggestion.
Yeah, no, great points, Peter. Harmony is important, and obviously, the more harmony you've got, the more successful you're going to be, no doubt. All right, we're coming to the end of the webinar, but what I would like to do, obviously, is firstly thank the panelists. But before they go, I'm going to ask them for one takeaway each out of the topics they've covered, which is important to take away for a family business. So I'll start with you, and I'll just run down on my webinar. Marianne.
My key takeaway would be to review your estate planning documents, and if you don't have them, get some put in place, but speak with an estate planning lawyer, because it's not just one document in isolation. There's a whole bunch of documents that comprise an adequate estate plan.
Thank you, Marianne. Thanks for your time today. Nadine.
So I'm going to stick with the old adage of if you fail to plan, you are planning to fail. Get advice early, have the conversations with your families, and make sure you're getting advice from lots of different parties as well. So, I mean, we get involved often in the valuation clauses in a shareholders agreement up front. So just make sure you're getting a broad spectrum of advice as well. No
doubt. Paul, over to you.
To borrow another cliche, which I love a lot in my role, is it's good to hope for the best, but you've got to plan for the worst. So while some of these discussions can be difficult, they're far more difficult if there's a dispute or if there's a falling out. So try and address it earlier.
Yep, very sage advice as well. Katie.
I'm just going to keep running with the cliches because it seems to be a popular thing. But I actually have two, because I wanted to say ditto to everyone else's, but I actually have two of my own as well. One is that don't assume that just because your family gets along now that they're going to after you're gone. Because having been executor on estates for RSM, I can tell you that does not happen. And I can also say to consider who it actually is in charge of your estate after you're gone, and putting people together just to make them get along also never, ever, ever works. So be really mindful of putting the right people around you at that point in time.
No, definitely. Peter.
Very difficult to go last because I think everyone's used all of the adages as well as all of my points. But I think I'm going to echo quite a few people here, pretty much everybody. But what I will say is having good conversations and challenging your advisors. I think it's really important that both accountants and lawyers, and that's why we work so well with some of our colleagues. Paul and I have done this together many times, as we have with Marianne. If you have these conversations in tandem with your clients, and I think it's almost incumbent on the client to want this as well, to demand it from their advisors, to actually have that conversation together, because we will see certain things that lawyers won't, and vice versa. And I think it's really important that that cohesion of minds is brought to the table so that there is that harmony both now and into the future. And as Paul said, plan for the worst. So just making sure that that worst case scenario is dealt with, and you get the benefit of various aspects from all of us when that happens. So that would be my suggestion, is just make sure your advisors are close to where you are thinking and the way you are thinking.
Yeah, definitely. The right advice is so important. But my one, and I'll end it on this, and it covers a few of those, but to me, the communication channel is so important, be it from a business relationship or a personal relationship. If you're open, upfront, having those conversations and willing to have them, because they sometimes difficult. You don't want to be the ostrich and put your head in the sand. To have them takes a bit of courage. To have some courage to have those conversations, but it's going to be a better outcome when you've had them than when it's not. You may not like it, but it's certainly going to be better down the end of the track. As I said at the start, the Think Big report is out. Please go and have a look for it and download it. Speak to your advisor. And a couple of takeaways. Obviously, we've covered a few topics today in minutia, but certainly we can have greater conversations and so forth. But it is important to get your documentation right, get your structure right, which helps with asset protection and tax minimisation. But also make sure that you're reviewing those documents consistently and effectively. And we can help, whether it be RSM, whether it be some other accounting practice, whether it be Hitch Advisory, which we're thankful for having on today, or your own legal relationship. I'd like to thank all the panelists, but most importantly, I'd like to thank you all for spending the hour with us, and hopefully you got something out of it. And please make sure you speak to your advisors. Thanks very much.